Hi, RJ World 2022. I'm very honored to be with you today. My name is Dr. Sandra Pavelka, and I'll be presenting on restorative justice, public policy, and law, and international assessment and future perspectives. I have been here at Florida Gulf Coast University in Fort Myers, Florida, USA for over 20 years. I'm a professor and founding director of the Institute for Youth and Justice Studies. Prior to my position here, I was project administrator of the Balanced and Restorative Justice Project, funded by the U.S. Department of Justice and the Office of Juvenile Justice and Delinquency Prevention. We worked in states and localities all across the country in developing and implementing restorative justice. I have since applied restorative justice in my personal life as well as my professional life. I'm here to share some of that research with you today. I'm going to share my screen and my presentation with you. At the end, my to be, you will be able to see that contact information, and certainly reach out to me with any information that you would like to talk about or share any comments about the presentation. So today we're going to be talking about restorative justice, public policy and law, and its international assessment and future perspectives. Lawmakers and legal system administrators have sought to further the goals of management and policy while exploring a model for justice reform. This shift in the legal doctrine paradigm challenges traditional methods which hinder the possibility of solutions that articulate new values and goals to challenge, rethink, and refocus current systems. Restorative justice has become an emerging standard in law and policy while being considered a modern-day policy solution. To this end, legislators have passed laws and policies that have been included in restorative language, with its practices being implemented formally and informally to varying degrees by countries internationally. Law and policies specific to restorative justice set standards, principles, and procedures that must be followed and affect the way justice is being implemented in society. We have also seen the advancement in policy endorsements by a number of associations and organizations nationally and internationally, including the American Bar Association, the National Association of Community and Restorative Justice, the National Council of Crime and Delinquency, the National Council of Juvenile and Family Court Judges, the National Organization for Victims Assistance, the Office for Juvenile Justice and Delinquency Prevention with the U.S. Department of Justice, and the United Nations, including the General Assembly, the UN Commission on Crime Prevention and Criminal Justice, and Economic and Social Council. The international assessment, we will start with the African region. Restorative justice really had its beginnings in African countries due to a conflict resolution paradigm that brings together community members. In pre-colonial African colonial societies had the enforcement of justice, law, and order, which lies within the complex of relationships. Social pressure plays an immense aspect in achieving compliance because many community members are involved in traditional African justice systems dispute resolution. Therefore, if one were to deny the ruling given, they would shun themselves from the community. Restorative practices including family group conferencing and victim offender mediation or victim offender dialogue are popularly used throughout Africa because in many rural areas and urban settlements, the infrastructure for a criminal justice system is limited. Justice is centered on redress and received by the entire community to be justified. For example, punitive measures like imprisonment have never existed within African cultures. Many traditional practices are currently upheld because many modern legal systems recognize customary law. In Asia, there is really limited policy or legislation for restorative justice due to the fact that most restorative justice research, a relatively new academic field, is primarily Western based. And many countries in the Pacific Asian region practice a culture of harmony and peace with the self, among others, and within local villages, and peaceful coexistence between nations. Many practices have been influenced by Confucian legal doctrine. By placing social relationships over other goals, Confucian thought coincides with modern restorative justice principles. In rural communities in Taiwan, Indonesia, India, Pakistan, Malaysia, and China, community conferencing resolves disputes in lieu of the courts. The National People's Congress placed the Juvenile Protection Law in 1991 and the Preventing Juvenile Delinquency Law in 1999 within those codes and laws. The JPL mandates that the state and parents use education as the primary mode of punishment, while the PJDL stipulates that the relationship and rehabilitation shall be used when dealing with delinquency behavior. Formal cautionings are facilitated by the People's Bureaucracy, a state organization with statutory power to oversee the administration of justice, which has the ability to suspend prosecution and divert juvenile offenders. Informal cautionings, a form of community conferencing, are utilized by families and communities. Australia is deeply rooted in Indigenous history, and it was one of the first countries to legislatively institute restorative justice practices within its retributive system, beginning with the Wagga Wagga, New South Wales police conferencing pilots. With local success, pilot programs for police-run conferences were established in Tasmania, Queensland, the Northern Territory, Western Australia, and the Australian Capital Territory, where they continue today. The Young Offenders Act, NSW legislation of 1997, established youth justice conferencing as alternative processes to court proceedings when dealing with adolescents and set restorative justice practices guidelines. The Crimes Restorative Justice Act of 2014 set principles and guidelines for offering restorative practices to all Australians, victim or offender, and created the Restorative Justice Unit in the ACD Department of Justice. Phase 2 was enacted in 2016, where they accepted the first adult referral. The act was fully implemented in Phase 3 in 2018, where cases involving family violence and sexual assault were permitted, removing legislative barriers victims and offenders had to a restorative process. New Zealand, grounded in its Indigenous heritage, is a world leader in the restorative justice movement. The Maori people practiced Maori, where justice addresses such things as sharing the guilt, forgiveness, and anger, and deals with real life, not just the crime. If you operate an extended family, everyone is equally important, and the focus is on the group, not just the victim. Then you restore everything, including mana, personal dignity, as well as heal the offender. New Zealand's modern justice system is based both on traditional Maori and European system. Therefore, it inherently shares restorative practices. The Children and Young People's Wellbeing Act, the first of its kind in the world, limits law enforcement powers over arresting youth while implementing restorative practices over traditional court proceedings. This legislative act would be a catalyst for family group conferencing throughout the country and the world. The Restorative Justice Trust was formed in 1999 to refine, research, and promote restorative practices. Its impetus was brought on by Judge Fred McElray Auckland District Court, where he moved to facilitate adult family group conferencing in 1994, leading to the first government pretrial adult diversion programs in New Zealand and in the world. The Youth Offenders Act of 1997, instituting youth justice conferencing, was the most ambitious restorative justice language. The Sentencing Act, updated in 2002, includes a restorative approach to victims and offenders' relations while recurring and requiring the court to consider any outcomes of restorative processes that may have occurred. The Restorative Justice Unit of the Act 2004 established the Department of Justice and Community Safety, currently consulting and planning for the second phase. The Council of Europe was created in the aftermath of World War II to galvanize and uphold human rights throughout the European continent. It is distinct from the European Union itself, but all European Union members are Council of Europe members. The Council of Europe recommendation resulted in the passage of recommendation number R99, the 1999 recommendation, which calls for the expansion in the use of mediation in criminal justice and outlined a series of standards and principles for those practices. This recommendation would underpin the 2002 UN resolution and directive establishing minimum standards of rights, supports, and protection of victims of crime. These directives signaled a distinct change in the field, as noted by the decline in the use of terminology such as mediation in personal matters to the term restorative justice. The directive itself has led to the proliferation of a variety of legislative activities across the European Union, to developing services for crime and enhancing rights of statutory victims. The EU and the Council of Europe recommends all that are influential in setting regional as well as international policies because of legislative harmonization and obligations. The Council of Europe's Committee on Crime Problems, the European Forum of Restorative Justice, was more specifically the Restorative Justice Euro Task Force, comprised of representatives from Ireland, Albania, Belgium, Czech Republic, Estonia, Italy, the Netherlands, Poland, Portugal, and Scotland reviewed the 1999 recommendation. These representatives serve as project partners on a cross-European venture entitled Restorative Justice Strategies for Change. The 2018 recommendations call on member states to outline evidence-based standards in victim offender mediation while having a capacity to deliver service effectively and safely. Further, build upon the use of restorative practices within prisons and probation services, and facilitate the general awareness of the restorative practices throughout the justice system. Countries such as Bulgaria, Croatia, Hungary, Greece, and Portugal have experienced an overburdened penal system. Restorative practices were implemented for court diversion of cases that would otherwise result in the formal justice process. In practice, every juvenile justice system reform in the EU utilizes or enhances restorative practices, furthering the awareness of restorative justice in adult programs. Victim offender mediation is a common practice in the EU, with variation in its implementation. Community conferencing is not as prevalent across Europe, except in countries that have a national provision, such as Ireland, Belgium, Northern Ireland, and Scotland. Now, Ireland has one of the most pervasive restorative justice systems in the world, which can be traced back to its practice of Celtic law and its Gaelic history. The law not only mediated a balance between justice and crime, but the victim and offender as well, particularly in the areas of compensation and conciliation. During the Irish War of Independence, the courts would commence the concept of community justice. This includes local, regional, and national non-government organizations which forms an overlap within the state elements of restorative practices. Restorative justice strategies for change published a national strategy in 2019 and worked closely with the Minister of Justice to craft the 2021 Justice Plan, committing to work with all criminal justice agencies to build capacity to deliver restorative justice safely and effectively. How impressive is that? In addition, restorative justice is listed as one of the 9 strategic objectives to be prioritized under its goal of community safety, reducing reoffense, supporting victims, and responding to gender-based violence, furthering the institutionalization of restorative practices. Victim offender mediation is one of the most common restorative practices in Ireland. Ireland's probation service uses family group conferences for youth within its court. Probation holds offender reparation panels in the community operated by the National Police Service. District courts handle the delegation of these conferences and panels where reparations are agreed upon by both parties after conviction. Restorative justice commenced in the UK in the early 1980s by gaining influence from Canada's VOM program. Similar with Ireland and EU, its use of awareness in the criminal justice system were seeded by youth cautions and youth panels similar to juvenile diversion in the US. In the 1980s, the Home Office funded 4 VOM pilot projects that proved to be successful. Indirect mediation is particularly distinct to UK, where the victim and offender have statements relayed back and forth by a facilitator without making any contact. The 1998 Crime and Disorder Act outlined national guidelines and legislation that would proliferate restorative practices while allowing contact with victims and reparations. In 2015, the Minister of Defense updated the Code of Practice for Victims of Crime and set restorative justice standards, diversionary processes available to all victims of crime. The code for the Crown prosecutor sets a framework for alternative measures rather than prosecution for adults and youth. Latin American countries still practice many indigenous traditions which are restorative in nature. International organizations in the 1990s, particularly the Organization of American States, of which Canada and the United States are members, would spur countries like Argentina, Mexico, Brazil, and Costa Rica to form pilot NGO projects in the region that would lead to restorative justice awareness and legislation. Alternative dispute resolution started to proliferate throughout the region when previously it was only used in civil and commercial disputes. Argentina would develop a national mediation plan that would set up facilitators and arbitration locations. Chile would add conciliation to its criminal code while providing mediation for family disputes in 1994. Mexico's revision to their constitution grants victims' rights to be informed of the progress in a case, to participate in the prosecutorial process, and to receive reparation for the crime. In North America, we see Canada, which has embraced restorative justice with its rich history in demographics of Indigenous and Aboriginal cultures, and allows them to adapt to every unique community's needs. Restorative justice is enforced through the Youth Criminal Justice Act, which includes special provisions at the youth court level, recognizing the harm done to victims and communities while encouraging the victim, their families, and their community's involvement in the individual's rehabilitation and reintegration. Restorative practices such as family group conferencing, peacemaking circles, circles of support, healing circles, sentencing circles, and others have been an integral part of Canada's criminal justice system since the 1970s. Legislation has permitted restorative justice to be implemented in every federal, provincial, and territory government. Entree points for the referral to a restorative justice process can enter at any stages within the criminal justice system, from pre-charge, post-charge, pre-sentence, post-sentence, or pre-revocation. The Canadian Bill of Rights grants information pertaining to services and programs is available to all victims upon request. In 1996, the Canadian Criminal Code sentencing principle were revised to reflect restorative justice and community-based sentencing. Section 717 of the current criminal code suggests alternative measures when referring to sentencing. In the United States, there are 38 American states that have referenced restorative justice language in state code or statute, primarily authorized since the 1980s. However, there are currently no federal laws specific to restorative justice. The degree to which the state policy and legislation is explicitly or implicitly applied varies. Common language we see is pervasive across jurisdictions. The states have incorporated restorative justice statutory language that includes general provisions and intent, restorative practices, funding, and evaluation. However, few directives and structures are included to support systemic implementation, with adequate funding required for successful implementation of the stated policy goals. Restorative language commonly used in the state statutes and codes includes holding offenders accountable for their offense, involving victims and community in the justice process, obligating the offender to pay restitution to victims or a victim fund, increasing support for victim survivor roles in the legal system, improving offenders' ability to live more productively and responsibly in the community, and securing safer communities. For example, the juvenile justice system in Pennsylvania is distinctly guided by restorative justice principles, the protection of the public interest, to provide for children committing delinquent acts, programs of supervision, care, and rehabilitation, to provide for children committing delinquent acts and programs, and rehabilitation that provide balanced attention to the protection of the community, the imposition of accountability for offenses committed, and the development of competencies to enable children to become responsible and productive members of the community. So this is actually from my research from 2000 to current day, 2020 and 2022. Back in 2000, when I was writing my dissertation, there were only 19 states that included restorative justice in their state statute or code. And presently, we've more than doubled that. We're at 38 now in 2020, 2022, which is very impressive to see the growth in restorative justice in the states. And this is a nice depiction of the map from my 2016 publication in the Justice Policy Journal. There's some balanced approach language, for example, in Illinois, that includes imposing accountability for violations of the law and equip juvenile offenders with competence to live responsibly and productively. Kansas, very similar, promoting public safety, holding juveniles accountable, improving their ability to live more productive and responsibly in their community. Colorado has restorative language that includes protecting, restoring, and improving public safety, provide the opportunity to bring together effective victims and the community, juvenile offenders for restorative purposes. Further, while holding paramount the public safety, the juvenile justice system shall take into consideration the best interests of the juvenile, the victims, and the community in providing appropriate treatment to reduce the rate of recidivism in the juvenile justice system and to assist the juvenile in becoming a productive member of society. California as well includes language of restorative justice that seeks to protect society and from the consequences of criminal activity. And to that purpose, community restoration, victim restoration, and offender training and treatment shall be substituted for retributive punishment. Balanced approach language in Oregon, for example, includes holding the offender accountable and having personal responsibility, and also providing restitution to the victims and community while reducing juvenile delinquency. Pennsylvania as well has balanced approach language. There are 20 states specifically that address restorative practices in statute and code. For example, victim offender mediation in Minnesota, family decision-making meetings in Oregon, reparative boards in Vermont, community reparative boards in Maine, neighborhood accountability boards in Florida, and community juvenile accountability programs in Washington and reentry courts in Washington. Colorado is really looked at as a restorative justice model state. We see restorative language in their children's code to protect, restore, and improve public safety, provide the opportunity to bring together affected victims, the community, and juvenile offenders for restorative purposes. We also see in their Victims' Rights Act and the Restorative Justice Coordinating Council, which exists. $10 court fee is applied to juveniles or adults who are adjudicated or convicted of a criminal offense. These funds are allocated to support the Commission's administrative costs and to implement restorative programs. We also see key strategies in their division of youth corrections that includes delivering services and restorative practices. And the use of those practices, both in the justice system and in schools, including restorative chats, circles, restorative conferencing, and victim offender dialogue. The Longmont Initiative is really a self-funding regional pilot program that continues and includes adult and youth facilitators from schools and law enforcement that are actually trained in implementing these programs. So in terms of future perspectives, it's really important to see the fidelity of the model. If we're talking about restorative justice, it's important to see the principles that are being implemented as well as any practices. So the fidelity of the model, in my humble opinion, is key. Leadership is important. To see leadership at every level, in locales, in states, at the national or federal level as well. Advocacy. We must advocate for restorative justice in any way we can, both in the schools, in the justice system, in the communities as well, and to see what level we're able to attain restorative justice at those levels. Vision is so important. What do we envision in our community, in our states, in our countries, in the world, in terms of a vision of restorative justice? Law and policy, we've seen that today in terms of the presentation and how law and policy can then be affected and affect change in those countries. Funding is so critical. So not only having this in law and policy, but it's important for the legislators to fund these restorative justice programs within their states, within their localities, within their country. Performance outcomes, to actually tie performance measures and performance outcomes to the laws that are being presented to these practices and programs. And also to look at the degree of restorativeness in whatever program or practice that is being implemented. In conclusion, restorative justice is an emerging standard in law and policy, while being considered a modern-day policy solution for justice systems. Statutory support for institutionalizing restorative justice processes leads to significant implications in law and policy internationally. This research included examples of successful legislative actions, including standards, principles, procedures, and implementation efforts of restorative justice in countries internationally. Australia and New Zealand, grounded in Indigenous heritage, are world leaders in the restorative justice movement. Canada has embraced restorative justice with its rich history and demographics of Indigenous and Aboriginal cultures, while adapting to every unique community's needs. African and Ireland have pervasive restorative justice systems, which can be traced back to its early history. The EU has a long-standing commitment to implement and recommendations in the region and internationally. While other countries, such as the US, have increasingly developed and implemented restorative justice in law, policy, and practices. In conclusion, countries internationally have an increasing commitment to restorative justice law in policy and justice reform, with a means to think about and do justice differently. Here are some select publications, including some forthcoming work of mine that is on this very subject. It also includes the reference to my 2016 Restorative Justice in the States National Assessment that was published in the Justice Policy Journal, as well as other publications. And these are some select web resources as well. So thank you so very much. Here's my contact information, and I hope to then see you on the world stage again. And if you have any comments or questions, any good comments are appreciated. And thank you so much for listening to and seeing this presentation today, and stay well.